well-established conventions in terms of legal advice. Those arguments, I understand, were also rehearsed at the recent liaison committee, of which you were a member through your role chairing this committee, but I'm sure the House will be discussing that with the Attorney General this afternoon.
The reason I'm asking you, I'm of course well aware the Attorney General is appearing before the House later, is if the government is saying that this clear resolution of the House of Commons, which the Speaker has confirmed, is effective, it's not just an expression of the opinion of the House, it is an expression of the will of the House that certain documents should be provided for it. It does have implications for certain other votes that are coming up if the government is going to say, well, that was all very interesting, but we're not doing it. And really, I'm looking, I think, for reassurance that if the House of Commons votes for certain things to happen, which may well follow the result of the vote on the 11th of December, that the government is going to respect that and get on with it rather than saying, no, we're not doing it. It's a point about democracy in the House of Commons.
Yeah, I very much hear, Mr Benn, the point you raise. I'm always mindful myself of the Speaker and the directions that he gives. But it is an issue, as I say, the Attorney will address this afternoon. And I think it's best that, as the law officers lead on this, that they allow the Attorney General to address it.
But do you think in general, if the House of Commons votes and tells the government to do something, that the government should do it, as a general principle? Is that something you would subscribe to?
I think there's distinguished members of the committee. I look at Mr Chope particularly on this in terms of standing orders and how the House rules. As a general principle, when the House makes a direction, then obviously the government listens very carefully to that. But at the same time, it is also a point of long-standing practice that legal advice, for very well-known reasons of which you're well aware, which is if legal advice is disclosed, then there is a concern as to how that might impact in the future on the frankness and openness of legal advice. It's a very well established approach that legal advice is not published, but the law officer this afternoon will discuss this in more detail.
Okay, well, we look forward to hearing further later. And finally, to you, before I turn to Mr Robbins, why won't the government rule out no deal, given, first of all, it's quite clear we're not ready as a country, and secondly, given the documents that were published last week, it would do considerable damage to our economy?
Well, I'd rather put it as in we're ruling in a deal. We have a good deal that respects the referendum result. European colleagues have made it clear it's the only deal. It delivers on things such as a skills-based immigration system, taking us out of the fishing, being an independent coastal state, taking us out of common agricultural policy, things that I, as a Brexiteer, campaigned for, so it delivers on the referendum result. But it does so in a way that, as the Chancellor has said recently, that also manages our economic relationship with Europe, ensures we have the free flow of goods. So we have a deal on the table, which is a good deal. It's the only deal, and that is what, as a government, we should be focused on delivering.
Well, that's very helpful. Unfortunately, it's not the answer to the question that I put to you. The question I put to you is, why won't the government rule out leaving with no deal, given, in my view, we're not ready, and given the view of the government, as published last week, that it would do damage to our economy, and you've heard what businesses have said about the implications of leaving with no deal. How could any responsible government contemplate leaving with no deal?
Well, in your previous question to me, you said, Mr Benn, that the government should be always mindful of the resolutions of the House. The point that was, and therefore for the government to rule things out, one can't be certain, because the point, if we don't support the deal the Prime Minister has secured, and secured after a very hard-fought negotiation lasting over 2 years, where the Prime Minister fought day and night to secure a good deal for this country, a deal that honours the referendum. The point is, if we don't deliver on that, then we risk significant uncertainty, and as the Prime Minister has set out, that could be no deal, it could be no Brexit. I'm sure members of the committee reflecting different perspectives on the referendum will explore both sides of that. But the point is, we will move into uncharted waters, we will move into significant uncertainty, and that could be no deal, but it could also be no Brexit, and that's the risk. And both of those options, that uncertainty, will be very damaging for the jobs of your constituents, the jobs of my constituents, and that's why this deal is the right deal for us.
Well, indeed. I suppose, let me ask you one more time, would you personally support leaving the European Union with no deal?
Well, we're preparing for no deal. There's significant work
no,
going
we know you're
on.
preparing, but is it something that you, as the Secretary of State for exiting the European Union, would be prepared to support, to leave with no deal?
What I support, Mr Ben, is the deal that the Prime Minister has
Yes,
negotiated,
no,
and that is what we are focused on. But one cannot second guess, and your earlier question on the legal advice pointed to this very issue. One cannot second guess how the House will react. But it's the government's focus to deliver on this deal because, as a number of senior European figures have made clear, this is the only deal, and it is a deal that the business community support. It gives them the certainty they need for jobs, but it is also one that doesn't damage our democracy, because not honouring the referendum, the biggest vote in our history, I think will be hugely damaging for our democracy and be very divisive for the country.
Well, I hear clearly what you say. I would also just observe the job of government is to prepare for all eventualities, and
we are preparing.
You are preparing for a no deal exit. Now, Mr. Robbins, can I just turn to you? Can I begin by expressing appreciation to you and all of your civil service colleagues for the very hard work that you've put in over the last 2.5 years to these into these negotiations in what I think it would be fair to describe as quite challenging circumstances. So if you could convey those thanks on behalf of the committee, we'd appreciate it.
Thank you.
Do you think the customs backstop is a bad outcome for the UK, and if so, why?
I think that the backstop is not the future relationship that either the UK or the EU wants to have with one another. And so it is an uncomfortable position for both sides. And the reality, as you know, I think, Chair, in evidence from us, but also in your meetings in Brussels, is that there is not a withdrawal agreement without a backstop. That reflects, of course, also, as I've said to this committee before, Ministers' commitments to Northern Ireland and to avoid a hard border on the island of Ireland, rather than being something imposed upon us. So it is a necessity, and a slightly uncomfortable necessity for both sides.
Okay. In what way would it put our security cooperation at risk if it came into being?
So the provisions of the Northern Ireland Protocol do not extend current security cooperation. Everything that we want to do as partners for the European Union on the security front is in the political declaration, and I think ministers are pleased and satisfied with where that has come out, but none of that is automatically conveyed by the legal text of the Northern Ireland Protocol.
Okay. Can you tell us what the impact would be on trade between GB and the EU if we were to enter the backstop? What kind of friction would be involved? That wouldn't apply to Northern Ireland, but it would to GB-EU trade. So could you tell us what that friction would be?
I can't precisely, Chair, no, because that would depend upon a whole series of other factors, including explicitly the level of alignment and regulatory cooperation between Great Britain and the EU in those circumstances.
But how would that be determined? Because we could be having to take a decision on whether to enter the backstop, within a year and a half's time? The choice between, do we go for the backstop, do we go for an extension of the transition period? Are you saying that you would expect that something would be worked out that would add to what we already know about the backstop between now and then? Because we've had evidence that says there would be some friction, because obviously the GB would be in a different place from Northern Ireland.
So all I'm saying, Mr. Chairman, is that there is no presumption in the backstop of fluid trade between Great Britain and the European Union. What the text says is that the degree of regulatory cooperation between the United Kingdom as a whole and the European Union will, of course, be a factor in the way both parties decide how to set their systems of checks and controls. So nothing is assumed in either direction.
Why doesn't the word frictionless, which used to be the government's policy, frictionless trade, appear in the political declaration? Is it because we didn't ask, or the EU wouldn't agree to it?
So the government has put forward its proposals on how to achieve frictionless trade with the EU, as you know, vociferously, especially since the White Paper in July. And as I think the Prime Minister briefed you at the Liaison Committee last week, some of those proposals have gained traction, others are still challenging and difficult. I think what ministers were pleased about is that the political direction that's laid out in the declaration makes clear that it's the ambition of both sides to achieve as frictionless a relationship as possible, and that at the extreme, frictionlessness is not ruled out by the spectrum of outcomes that's described in that declaration. Okay. But I don't think ministers, least of all the Prime Minister, are hiding from the fact that we've still got a job to do to convince people of the detail of every bit of that.
I think the key in the deal is it will be a sovereign choice, and throughout the negotiations, the Prime Minister was told it was a binary choice. It was a choice between Canada or a choice between Norway. And I think what the political declaration makes clear is actually she has secured a bespoke relationship which gives a spectrum. So there is a choice between frictionless and alignment, but that is then a sovereign choice as part of that negotiation.
And finally, from me, when it comes to services, because I've asked you about goods, but when it comes to services under the backstop, if it kicks in, then, for example, British broadcasters can currently broadcast to all member states with a single licence. Would that come to an end if the backstop came into operation? It's a factual question.
Would you like me to take that, Secretary of State? The protocol only relates to those aspects of EU law that are required in order to avoid a border in Northern Ireland. So that's about tangible goods. It says nothing about services. So if the backstop were to apply in the absence of any other agreement with the European Union, there would be no services relationship.
So there'd be no services relationship, so the broadcasters couldn't do that anymore. Mutual recognition of qualifications for architects and lawyers, the current arrangements would come to an end. So any arrangement that our services sector, which is 80% of the British economy, 80%, would come to an end under the backstop. But that is correct, is it?
So a whole series of relationships in both directions between the EU and the UK, in the absence of any other agreement, are not catered for by the protocol, which is why it is an uncomfortable situation for both sides.
But then the government in its Chequers proposals never asked for anything on services. That was the whole point. So I think it's a bit hard to blame the backstop for the fact that it won't cover services, because the government didn't ask for services when it came out, the Chequers proposal came out in the summer. I think that is correct, is it not?
Well, may I answer
that,
Secretary of State? I don't think that's completely fair, Mr. Chairman. I mean, the political declaration, I think, remembering the hours that we spent discussing it, is clear about the level of ambition on both sides on services, and says explicitly that it wants those service relationships to be well in excess of the arrangements standard under WTO arrangements, and indeed go beyond those agreed in recent EU FTAs. So already, like in other aspects of the political declaration, the EU side is agreeing with us that this should not be a standard third country relationship.
I do acknowledge that point. The point I was merely making, that it's not covered by the backstop, which could kick in. Anyway, that's very helpful. Stephen Crabb.
Thank you, Chairman. Good afternoon. Can I stay on the subject of the Northern Ireland backstop, because I think it's probably one of the most problematic areas within the withdrawal agreement. And can I start, Secretary of State, by asking you, are there any provisions of that backstop protocol that you have concerns with, or are you wholly comfortable with the way that it's drafted?
Well, there are compromises. I think with any negotiation, Mr. Crabb, there are compromises.
No, and concerns that you have. What would be the specific concerns that you have about the way the current backstop is drafted?
Well, I think the first point I make is the intention is not to go into the backstop. So there's a number of safeguards, one of which is the option to avoid going into the backstop. There's also things like, for example, extending the interim period, implementation period. There's also safeguards in terms of coming out of the backstop, in terms of the best endeavours, the requirement for the timetabling, the option in terms of technology, which was specific language that was put into the political declaration. And then, as Mr. Robbins has just set out, actually the backstop is very uncomfortable for both sides, because, for example, if you take fishing, on the fishery side, the EU27 would lose all access under the backstop to our coastal waters. So the safeguards in terms of the front end of the backstop, the safeguards at the back end of the backstop in terms of coming out, and there's a mutual interest in not retaining, not being stuck in the backstop. And that's reflected, for example, in Part 5 of the political declaration that sets a time frame. So there's a mutual desire on both sides not to be in it, but in terms of the areas that are less appealing of it, obviously there will be, I think, 92 pages of rules where there would be alignment. And obviously one would have preferred not to have required those 92 pages. But the reason for those 92 pages, we should be clear, the reason for the backstop is because it is unique within the United Kingdom in terms of the land border and in terms of the history, in terms of the peace settlement. And that is why the special bespoke circumstances have been arranged. But there is a common desire on both sides not to get into the backstop. And certainly for it not to become a permanent feature. And I think a lot of colleagues have been concerned around the question as to whether we would get out of the backstop. And as I say, there are 3 tiers of safeguards to avoid that happening.
So is it your view that the best endeavours clause and the fact that you believe that both sides will be heavily incentivised to avoid going into the backstop is enough to make colleagues in the House swallow what I think you would admit is an uncomfortable wording of the way the EU can veto us unilaterally leaving?
Well, I think we need to make the case because I think it is actually quite a complicated area of law. I think the legal wiring between the withdrawal agreement and the political declaration takes some unravelling. And I think sometimes people reacted very quickly to the withdrawal agreement, and actually and I think there's a good opportunity with the Attorney General today, as one gets a clearer picture of that legal wiring, one gets a better understanding of the obligations it places onto the EU. And I simply point out, for example, some colleagues were concerned when the Prime Minister in the joint report in December made the commitment of the backstop, because they said it was binding. Well, the same applies in terms of political declaration. It might not be legally binding, but politically it would be very difficult for the European Union to row back from the commitments they've given. And part of the reason I think the negotiation for Mr Robinson and his team has been so difficult is because the European Union take that language seriously. I think if it wasn't meaningful, if they didn't need to rely on it, they perhaps would have been more relaxed as to actually what went in the text. And I think the reason that has been so hard fought is because it is a negotiating instruction to both sides and therefore will have a significant impact in shaping the phase 2 discussions. But I absolutely accept that a lot of colleagues across the House have been concerned in terms of the ability to come out of the backstop, and that is something we need to explain. Thank
you, Secretary of State. Can I ask, therefore, to Mr Robbins, the Times recently reported that you and your team had drafted a termination clause for the backstop, which included a specific unilateral mechanism that would allow the UK to quit the backstop if it so desired. Were those reports correct?
Ministers asked us to look at a whole range of options for how to bring the backstop to an end, and so we did. And the Prime Minister and other ministers tested some of those out on European partners. But what we went into the negotiation with in the end was a text that delivered the termination clause very much as it's laid out there.
Did the text of the termination clause that the Times reported on, did that ever go to Cabinet for consideration?
I don't think if I may say so, I think I should allow myself to be governed by the normal convention. I don't talk about what's gone to Cabinet or not. All I can certainly assure you, as I hope the Secretary of State will back me up, is that ministers have had advice on the full range of options, and what was tabled in the end was a ministerial decision.
But you said a moment ago that it was tested on European counterparts, so presumably we can infer from that they pushed back pretty strongly on that draft of a termination clause with a unilateral mechanism.
Well, I think what's always been clear is there can't be a deal without a backstop, whichever, and we may come on to the other deals that colleagues have been exploring, but I think a very clear narrative. Obviously, I've only been at 2 cabinets, so I wouldn't have been at the cabinet where that may or may not have been discussed. But the point is, what has always been clear is that whichever deal is entered into, there will need to be a backstop. So whether it's Canada, whether it's Norway, whether it's EA+, the various options colleagues have floated, they would always need a backstop.
can I ask you then, Secretary of State, when the deal gets voted down a week tomorrow, will you be advising the Prime Minister to resurrect Mr Robbins's draft termination clause with the unilateral mechanism to take to the summit the following weekend to ask EU leaders to reopen the text of the withdrawal agreement and insert such a termination clause?
Well, firstly, it's government's intention to win that vote. That is what we're focusing on. You would expect me to say that, Mr Crabb, but that is the case. And I think as minds are focused on the uncertainty of the alternatives, and we may get into a wider discussion of those uncertainties and whether those other options would themselves command a majority of the House, then it is very clear that the only deal is the Prime Minister's deal. Yes, there's some compromises in that. That's the reflection of a hard-fought negotiation. But that is the deal, and that's the deal we need to secure.
Thank you very much.
Thank you very much indeed. Emma Reynolds.
Thank you. Good afternoon. If the UK and the EU do enter into the backstop, can you confirm that under the withdrawal agreement that the UK government cannot unilaterally withdraw from the backstop, and actually that decision would have to be taken by the joint committee as referred to in the withdrawal agreement, which is made up of representatives of each side?
So you're correct that it would be a question for the joint committee and then the arbitration process, and that's a normal approach. The point about that is, again, the idea that the EU has some sort of veto on that process is not correct, because there are requirements in terms of, on both sides, to act in good faith going through that. And any interpretations of law, because again, a question that's been raised is, well, what would the role of the European courts be in that process? The role of the courts is not to determine. The role of the courts is simply in terms of any interpretation of EU law. So the role of the courts is regarding the factual position, what is the interpretation of the law, not determining the case. So it would be for the joint committee, the arbitration process, and there are requirements in terms of acting in good faith as to how that would need to be conducted.
I understand what you're saying, but so it is the case that the UK government couldn't withdraw from the backstop unilaterally. That's certainly the case.
Because it's an insurance. I mean, the whole nature of the backstop is an insurance. But as we've already covered, Ms Reynolds, there's strong incentives, firstly, to avoid going into the backstop, but secondly, as to why, from a EU perspective, they themselves would not want to stay. And if indeed you look at the comments that President Macron raised the other day, the point about those comments relating to fishing is that on day one, the EU 27 would lose access to UK coastal waters under the backstop. Now, that would be a difficult conversation, I'm sure, for EU leaders to have with their own fleets. That is a further indication of their desire not to remain in the backstop. And indeed, the political declaration reflects that, because it also gives a clear timetable in Part 5 to incentivise those discussions.
I hear what you're saying, but the factor going in the other direction is obviously that the need to avoid a hard border on the island of Ireland. And my question really is, the backstop could become quite long-term if the EU and the UK cannot find a solution to that problem. If you cannot come to an agreement that avoids that hard border, then the backstop will remain in place.
I don't think so, because but it's
What's the point of the backstop,
it's a key issue, and it's one that a number of people, I think, have been concerned about. So firstly, it would be difficult from a European perspective if there was any suggestion of permanence, not least because Article 50 doesn't allow a permanent relationship. So the very nature of that would open up litigation risk for firms in the EU 27 who would feel that Northern Ireland business, in having the best of both worlds, would have a trade advantage compared to firms within the EU 27. So it might be the case that this committee would take the view that the willingness of the European courts to react to Her Majesty's government would be limited. But what I think is much more reasonable to conclude is that the European courts would react to, for example, a French firm that felt it had a trade disadvantage compared to a firm that was able to access the single market without the UK paying any lump sum in terms of its fees, without being subject to the four freedoms in terms of freedom of movement. And that's why, if one looks at the media reports, some in Europe have criticised the backstop. I know it seems odd in the context of the UK political debate, but some in Europe have criticised the backstop because they feel that Mr Robbins has got an advantage in the negotiation, and the Prime Minister's got an advantage because it gives access to that market without the financial contribution and without freedom of movement. That's another reason why it's not an advantageous position for the EU. And I give a third.
But there could be friction. Let's just be clear about that. There could be friction, and we've taken evidence on this, between the UK and the EU, and Mr Robbins has just conceded that this is the case depending on regulatory decisions on regulatory equivalence. But the situation with regard to Northern Ireland and the rest of the EU is different to that with regard to the UK and the EU. Isn't that the case under the backstop? So
well,
what you're talking about is actually access for Northern Irish, the Northern Irish economy, to the rest of the EU, not the whole of the UK.
Well, there's already different aspects to this. So if you take animals, for example, there's 5 million animals flow to and from across the Northern Irish border as it is. If you look at the moment between the GB and Northern Ireland border, there's around 30 checks, particularly around animals at the moment. So there are already existing issues there. So some of these points are already in place.
Okay, sorry, one last question, but on the future relationship. Mr Robbins, you were there in Salzburg, as I understand it. Given the response from EU leaders at Salzburg, particularly to the economic proposals in the Chequers plan, to what extent do the economic proposals in the Chequers plan still constitute the UK's negotiating position on the future relationship? The response being negative, just to be clear.
Thank you, Ms Reynolds. I mean, firstly, of course, the response to the white paper at Salzburg and before and after it has not been perhaps as wholly negative as some have portrayed it, including on the economic side. And I think if we had time to go through the whole declaration, there are many aspects of our white paper proposals which are welcomed and reflected in where the joint declaration has ended up. I think, it's for Secretary of State to speak for the government's policy as we enter into the next phase, but what I can say with confidence is that the position that the government took in the white paper, this declaration allows us to continue to argue for that in the areas where we have not yet nailed it down.
And can I ask why, given that that is totally uncertain, I mean, I'm just to echo what the Chair said, thank you and your colleagues in the civil service for all the work that you've put into these many documents. I know you've been hard at it for years, not weeks or months. But it is the case that the political declaration is not legally binding. Therefore, it's still unclear whether our future economic relationship will look more like the EU's economic relationship with Canada or Norway. That's still not clear. Because the negotiations really only just begun on the future relationship. Is that the case?
May I have a first word of that, Secretary of State? So just one thing I think the Secretary of State's already mentioned, but let me just amplify it a bit. It is not a legally binding document, the political declaration, that's of course true, Ms Reynolds, but it's extremely unusual, I think unprecedented in my experience, for a political declaration like this to be explicitly referred to in an article of an international treaty. And so in Article 132 of the withdrawal agreement there is, no, I've got my numbering wrong, it changed, 184. There is...
in the previous draft it was 132
yes,
of them.
we added 50 odd articles. The 184 is the one that specifies that the declaration dated as this declaration is the basis then for the negotiations to proceed. So that is, as Secretary of State was saying earlier, that's not just a moral commitment and a political commitment, but actually a failure to proceed in good faith with the decisions taken in that declaration would be ultimately something that's internationally enforceable. The second thing is that I think I would say that this declaration does give actors in the UK and the EU a great deal more confidence than they would have had before its signature. For a start, some of the basics of the economic relationship that were in doubt until we had achieved this declaration are now certain. There should be no tariffs, no fees, no quantitative restrictions. a whole series of things which in a standard third country relationship would not be there are declared as, would be there, are declared as not going to be part of our future economic relationship. And I think it's fair to say, I mean, European officials have said this for their side. Once the Union makes an offer like this, it's very, very hard for it to step back from it. And I think one of the achievements ministers should be justly proud of over the last few months is that in its March guidelines, the European Union attached a long list of conditions to such a close economic relationship. Some of those, frankly, were a bit extravagant. And what this declaration does is it pares those down to a much more common sense level. There are some areas, particularly in regulatory cooperation on goods, where the true extent of how far we can manage away some of the checks and controls and frictions that might be part of a standard economic relationship is not yet fully bottomed out. But the key achievement in this document is that that is still to play for in the second phase of negotiations. And indeed, in mentioning the spectrum of outcomes in the way the European Union has jointly signed up to doing, it concedes of there being a relationship between the kind of obligations the UK and the EU are freely going to enter into with one another and the degree of friction in the trading relationship. So as the Secretary of State said a moment ago, basically both sides have agreed this is not quite the binary situation that some made it out to be some time ago, where you're either Norway or Canada, if you forgive the caricature.
Okay. Thank you very much. Jacob Rees-Mogg.
Mr. Robbins, can I first ask you about today's Daily Telegraph and a couple of extremely interesting comments that are attributed to, which you may wish to dissociate yourself from, and I at least want to give you that opportunity. First of all, he, that is to say you, argued that extending the transition period after Brexit would provide a more cast-iron escape route. Is that your view?
You'll expect me to say, Mr. Rees-Mogg, that I'm not going to comment on an apparently leaked document, but it is certainly true that if the UK were to enter into an extension to the implementation period, some of the other negative consequences of being in the backstop that the chairman referred to at the beginning would not apply.
Thank you. Now, I thought you'd say you wouldn't comment on a leaked document, so I'll ask again whether it's your view on the next quotation, regardless of where it's come from. We should not forget that the backstop would, even with a UK-EU customs union, is a bad outcome with regulatory controls needed somewhere between GB and NI, serious and visible frictions and processes between GB and the EU, and no security cooperation provided for. Is that broadly your view?
All I can do is reiterate, Mr. Rees-Mogg, that the backstop is definitely an uncomfortable outcome for both sides.
Well, at least for one side. Thank you.
I think for both, Mr. Rees-Mogg.
Well, I'm not at all convinced about that they've got us exactly where they want us. And Secretary, can I come to you now? Because you mentioned that this would only be temporary. But temporary in EU terms can be quite a long time, can't it? Norway remained in a temporary agreement before the EEA was established for 22 years. So when the government says temporary, that's not a time-limited temporary.
Well, you're correct that people can take different interpretations, Mr. Rees-Mogg, of temporary. The point is, what are the incentives? And what I alluded to earlier was, would the EU27 be comfortable with losing all access to our coastal waters on day one of a backstop? I don't think they would. I think that would be politically difficult. Would they be comfortable with the fact that businesses would have access to the single market without the vast sums that you and I campaigned against, without the freedom of movement? I don't think they would. Would they be comfortable with the litigation risk of firms claiming a trade distortion? Would they be comfortable with the potential disruption to their own future free trade agreements as they try and calculate those without having clarity as to what the population size on which those free trade agreements? So it is not perfect for either side, and if one doesn't, because I can see from your reaction, accept any of those safeguards, there is also, and this followed the work of a number of colleagues in government, a clear language in the political declaration in terms of things like the use of technology to expedite a solution. Because actually what we're really debating here is a huge focus on the withdrawal agreement, which is the winding down element, and the backstop is a part of that. But the key opportunity for us is the future trade agreement. That is the way we get out, well, we try and avoid going into the backstop in the first place. But if that were to arise, and there's ways of avoiding it with the implementation period, but if it were to arise, the key is to move into the future trading relationship.
Your point, Secretary of State, on the backstop being sound attractive for them, surely is slightly contradicted by your suggestion earlier that no deal was possible without a backstop. If it's so bad, why did the EU insist upon it?
Because the EU cannot enter into a permanent relationship whilst we are still a member. And therefore we need to have exited in order to reach that future agreement. Now, one of the issues, which I'm sure you and I have, well, if I may just finish the point, please. One of the issues I'm sure as Brexiteers you and I have often been lobbied about from business is they don't want two sets of changes. They want to have one change. Now, if you come out on a no-deal situation with the World Trade basis, then one assumes one is also looking in the future for a free trading arrangement. Well, you are then into having more than one change. One of the attractions of the Prime Minister's deal, through having the implementation period, is not only do we give businesses greater certainty in the short term, up to the end of 2020, but then beyond that, when a change is made based on that future arrangement, it is done because we have left at the end of March.
But that assumes that no changes are made in the UK ex-Northern Ireland post the implementation period under the backstop, because you're saying that there would only be the one change, and therefore you're saying that the backstop would not allow GB to use its flexibility to change regulations.
No, what I'm saying is
otherwise there will be two changes.
What
doesn't exist.
What I'm saying is, what I hear all the time from business is they want certainty. They want as much clarity as possible. In Parliament, we have had over the last week or so a huge focus on the withdrawal agreement and on the backstop. In essence, the winding down provisions of our relationship. What needs to be the focus and what the phase 2 discussions are about and what the mandate that is set out in the political declaration unlocks is actually the future relationship. And it is slightly paradoxical that we've had all this fixation on the backstop and the withdrawal and the winding down provision, when actually, as a Brexiteer, as an optimist for the future, as someone who wants to trade with the globe and actually look to the wider world, what we should be looking at is that future trading relationship.
There's an inherent contradiction, isn't there, in saying that the EU couldn't use the facility under Article 50 to negotiate the future framework, that it can have a backstop without an end date, but it can't go further than that. It seems to be the EU can agree what it feels like.
No, I don't accept that. I think one of the features, and I always feel this whenever I read the European Union, the correspondence that particularly write on the European Union, what is always striking is how much their approach is informed by the legal process. And I think sometimes that's something we don't give sufficient weight to within the UK. And it is the legal process in Europe that a permanent relationship, a permanent trade arrangement cannot be reached until we have left. I am committed to ensuring, and the Prime Minister is committed to ensuring, that we do deliver on that. We do leave the EU on the 31st of March, and by that point we're then in a position to be able to agree a trade agreement. But we can't do that before we have left.
It's not quite what your predecessor but one said. He said the trade agreement could be agreed a nanosecond after we'd left. It couldn't be formally agreed, but it could be negotiated.
Well, actually, I think, with respect, Mr. Rees-Mogg, you're splitting hairs there, because the point I was making was you can't agree it until we've left. The point you have just said is it couldn't be agreed until we're left. Well, one can argue as to how quickly after leaving it can be agreed, but the point of law, as a former lawyer, the point of law still stands. The legal point, and I come back to the point that the EU takes a very much an approach, as I understand it, where its legal process is very important to it. And the point is you cannot agree as a matter of law, European law, until we've left. That's the point.
The history of the EU is that it's managed to adjust its legal process whenever it's needed to in other cases.
Well, the law does evolve, of course.
Of course, and when it needed to bail out Greece, it suddenly found that laws didn't apply at all. But let's come to some specific points of Annex 2, Article 3, subsection 2. The United Kingdom will apply to its customs tariff may not, under any circumstances, which is lower than the common customs tariff for any good or import from any third country. When previously has the UK allowed for taxation without representation? Because the EU will be setting our customs taxes, and we will have no say on it once we've left.
You're talking in terms of the Northern Ireland Protocol?
No, this is under the backstop. Annex 2, Article 3, subsection 2. Taxation without representation.
No, I don't accept that at all. I've got that precise text in front, so I'll pick that up and happily write to you on it. But we've covered why the backstop is undesirable, we've covered why we have no desire to go into it, and we've covered the safeguards that there are in order to allow us to exit from it.
But if the EU raises tariffs, we will have to follow, and we will have no vote on that at all. So it is taxation without representation, a fundamental constitutional principle given away in the backstop.
No, I don't accept that at all.
Okay, but you don't seem to know about it, which is a bit of a problem. Can we go also then to Article 174, disputes raising questions of union law, because the government has consistently said that the jurisdiction of the ECJ will no longer apply once we have left, with the exception of citizens' rights. But this says that the arbitration panel shall not decide on any such question. In such case, it shall request the Court of Justice of the European Union to give a ruling on the question. This is not discretionary, this is absolute. But when you look at some of the things that will be included in the backstop, for Northern Ireland, specified EU law on VAT and excise, environment, electricity markets and state aid apply to the UK in respect of Northern Ireland with backstop, and they will all be subject to the jurisdiction of the European Court of Justice. Can you explain how this squares with the government's stated view that we will be out of jurisdiction of the ECJ?
So I think there's a limited area in terms of Northern Ireland. So the single electricity market is distinct anyway. Firstly, that was a bilateral agreement before. So that was a bilateral agreement entered between Ireland, the Republic of Ireland, and the UK. So that wasn't actually done through the Commission, and there's very good reasons.
Under the ECJ.
It will.
Yes. So that's an addition to ECJ jurisdiction, rather than a subtraction in this agreement.
So there are, again, it comes back to my earlier point in terms of winding up issues. So there are, in terms of, this applies also to goods, which I think was inherent in your question, which is there are certain areas, the same actually applies in terms of citizens, where as part of the winding down arrangements, there are certain rights in place, certain arrangements in place, which are currently within the jurisdiction of the European Court. And that will continue within the backstop. I've touched already on the desire to come out of the backstop. But within Europe itself, VAT is not harmonised. There are variances within Europe. So VAT is not something that is static across. What European law says on VAT is it's around the minimum rate rather than the constant rate. So in the backstop, Northern Ireland would have to maintain the minimum VAT, which goes to the debate, for example, one sees in the press on things such as the tampon tax and whether that could be changed. So there is an issue in terms of Northern Ireland in terms of the minimum rate, but the UK obviously can align with that. So that's from a unionist point of view. That doesn't mean there's a distinction. But I think it would be misleading to suggest there is one VAT rate across Europe, because actually it's the minimum bit, not the harmonised bit.
I didn't begin to imply that, but you mentioned the tampon tax. That couldn't be removed in Northern Ireland under this, nor could VAT on domestic fuel be removed in Northern Ireland, and the European Court of Justice would adjudicate on that. That is all correct.
Well, we've said, in terms of the...
Because I've just...
Need to be the last part.
Okay, I've got one final point after that. On that issue, the European Court will be ruling when the government has said we'll be out of jurisdiction of the court. So when the government says things, are we to assume that there is a footnote saying except in certain circumstances? Because the government doesn't particularly footnote its comments. And my one final point is bring your attention to Article 4. Because Article 4 is at the heart of this, because it establishes this treaty as superior law and requires that inconsistent or incompatible domestic provisions may be disapplied. So the suggestion that some members of the government could make, that if we don't like the backstop in the end, we can simply pull out of it, we would then be breaking domestic law, because we have agreed that this treaty should have the same status, the unusual constitutional status of the European treaties?
I mean, we will, and Parliament will get a very good opportunity to debate this in terms of the withdrawal, the WAB, in terms of the bill that is coming forward. But in terms of how that applies, you're correct in that there will be a direct effect element to those provisions, and so there will be in essence a reach into the bill. The bill will give direct effect to that element, but it is a very limited element, and it really goes to the heart of my reply to Mr. Crabb, which is there have been some limited compromises within this. But what matters here is the bigger picture. The specific circumstances of Northern Ireland have required some compromises, both because of the land border and because of the history in terms of the Northern Ireland peace and the Good Friday Peace Agreement. But that is very limited in its scope. Some of those actually predate, such as the single electricity market, actually predate this and were done on a bilateral basis. Some of it relates to the common travel area and how that interrelates. So there are bespoke issues in terms of Northern Ireland. Now, one can take a very purist approach and say that none of those compromises should be entered into. One shouldn't have arrangements distinct to the Northern Ireland situation. But I think actually what's probably, rather than my comments on this, if you look at the views of the business community in Northern Ireland, if you look at the views of the Ulster Farming Union, if you look at the biggest manufacturer in Northern Ireland, Bombardier, and the head of the Belfast plant, what you hear consistently from the business community in Northern Ireland is, yes, there have been some compromises. Yes, there are some very limited areas, very limited, and we can all sort of play at sort of picking out individual bits of law where the courts have a reach. But actually the bigger picture here is this is a deal the business community in Northern Ireland support. This is a deal that the farming community, the farming union, the Ulster farmers support. And that is because they see the benefits, and indeed the same benefits that some in the EU 27 are concerned that businesses in Northern Ireland will have the best of both worlds. And that's why they support it.
Thank you very much.
Do need to move on. Peter Bowen wanted to come in on this issue. Yeah.
Going back to something the Secretary of State said, he referred to the implementation period. We were told clearly by the Prime Minister on many occasions that the implementation period would be time limited, and it was an implementation period, not a transition period, so that the time that the implementation period was agreed, we would know what we were implementing. And one of the reasons she said that is she said she didn't believe Parliament or the British people would put up with £39 billion of their money being given to the EU without the knowledge of what was to come. And I think she slapped down any minister who called it a transition period. And she also said, Chairman, that nothing is agreed till everything's agreed. And Mr Barnier said, by October of this year, we must complete the work on the withdrawal, and between October and March, we will finalise what we're implementing, so that when the signing of it occurs, we will know the complete deal. That was the policy. When did that change, Secretary of State?
Well, I think on your first point, which is
no, when did it change? I don't want the waffle. When did it change?
Well, I think there were several points you raised, so I was just going to go through the different ones. So firstly, you raised the issue in terms of whether the implementation period is time limited. I think the answer to that is yes, it is. It is up to the end of 2020.
No, it's not. No, come on. No, Chairman, you can't get away with that. You know that there is an option to extend that.
Well, it's just coming on, though.
So it's not time limited, is it?
Mr. Ben, never mind trying to get away with it. I was just about to make the point. So the point I was seeking to make, if I may, is it is time limited to the end of 2020, but with an extension of either 1 year or 2 years. But even so, by its nature, that is time limited. I would hope that is a point of consensus.
No, the trouble is the Prime Minister said it was time limited to 2 years.
Well, it's 2 years with the option of a 1 year or a 2 year extension.
Changed? When was the policy changed? That's all I'm asking.
Well, I've been in post for 16
days.
Sorry,
so I don't
particularly.
Perhaps it should be directed to Mr Robbins, who was there. Mr Robbins, when was the policy changed?
So the policy on the implementation period for some time has been that we would aim to have concluded all of the negotiations of the future relationship in order to allow it to take effect in December 2020, and that's what the treaty sets out. And in the closing weeks of the negotiations, ministers felt it was prudent to allow for the possibility of extension. It's no more than a possibility, and it has to be by mutual consent.
But I think
No, sorry, I'm still trying to find out when the Prime Minister's clearly expressed policy to Parliament, which kept members of Parliament reasonably happy on compromising that they could go along with, when was that policy abandoned? Now, I expect to say you've only been there 2 weeks, so you wouldn't have been there. But Mr Robbins, you've been there right at the top. I'm not asking for any explanation. I just want to know when was it abandoned? You know, a month ago, 4 months ago, 6 months ago?
So I don't think that policy has been abandoned with respect, Mr Bone. The policy is to conclude the negotiations of the future relationship in time to leave the implementation period on time by the end of 2020, and the treaty sets out that we will use our best endeavours, both parties, to achieve that aim.
Yeah, no, but you have to accept, Mr Robbins, that is a complete change in the policy of the Prime Minister, clearly expressed that at the time when we signed to leave, we would know what we were implementing, whether that was a free trade deal or what. Now, that has been changed. That policy clearly has been changed.
No, I don't accept that, Mr Bain. I think the 2 points at the heart of your question is, first, is there a time-limited implementation period? The answer is yes, to the end of 2020. Now, we have given ourselves an option, but the fundamental point is it is time-limited to the end of 2020. That's the first point. Secondly, will we know what we're implementing? We have a clear framework. Mr Robbins has already talked in terms of the amount of resistance there had been, the extent of the detailed negotiation to secure that, and that is the clear negotiating instruction. And what it delivers is a bespoke arrangement, which is something that the Prime Minister was consistently told she wouldn't be able to secure.
But that's all well and good. But the Prime Minister clearly said we are not going to spend £39 billion of taxpayers' money without knowing exactly what we were going to implement. Now, that is a change in policy. I'm not saying whether it's a right or wrong change in policy. I'm just asking, when was that decided and how was it decided?
Well, I don't accept the premise that it was a change. I think the issue in terms of the 39 billion, which I know you've raised a number of times in the chamber, and very happy to get into the detail around the methodology of that, what that relates to, why that range of 35 to 39 billion has been agreed. But that has been agreed on the basis of us maintaining our relationship with our closest trading partner. That is what the political declaration allows us to do, and what it does is give clarity as to the fact that we are not going to be in a standardised arrangement as other third countries, and reflecting the very close, over 40 years of relationship, the shared values that we have with the EU 27, and reflecting that, the Prime Minister has secured a bespoke deal, and that is what we're paying for. Now, the 39 billion we can very happily get into,
I'm
but
going to
there are a
say
number
time,
of...
Mr Chairman, because we've heard all this. It really doesn't help the debate when politicians and civil servants just don't answer a straightforward question, is when did the policy change? And if you had something to implement, then you would be fair, but you have nothing to implement. So the policy has been changed, and when? And if you don't accept that, it makes the whole of these sort of debates farcical. No, you're flying in the face of the facts.
With respect, I don't accept that, because the policy hasn't changed. The 39 billion, I mean, there's a whole different debate we can get into the financial settlement, into what David Cameron agreed in 2013 as part of the multi-year, 7-year settlement, the fact that under the implementation period it takes us to the end of 2020, and how those liabilities sit with the trade-off in terms of what assets we're getting back from, for example, our shareholdings from the EIB and others. I mean, that is a very different debate. Obviously, we can explore the issue of the 39 billion and the negotiation Mr Robbins and the team had, but that is a separate issue. The issue is that the Prime Minister has always been clear that there would be a time-limited implementation period. That is the case. It's till 2020. Personally, I think it's a good thing to have an option. Why would we not want to have an option? I don't think that's a negative. We don't have to use it. So it strikes me as a logical thing to have. But it is time limited to the end of 2020.
Thank you, Chairman.
And beyond that, it's part of
the
arrangement.
Okay. Pat McFadden.
I'm sorry, I'm a little bit croaky. Secretary of State, could I ask you if you think there are any circumstances between now and next Tuesday where the Prime Minister will pull the vote.
No, I think the vote will happen on Tuesday, and I'm very much looking forward to making the case. I think the Cabinet has an important job. It's for the Cabinet as a whole to make the case ahead of Tuesday, and I think certainly what I hear from businesses up and down the country is many businesses themselves are making the case because they don't want the uncertainty that will flow if this vote does not go through.
So there's no chance that sometime between now and next Tuesday, the Prime Minister will look at the likely numbers in the Commons and decide not to proceed with the vote on Tuesday. That won't happen.
I think the meaningful vote has been set out for the 11th, and that is what I expect to be the case.
Expect?
Of course.
Anything stronger than expect?
Well, I mean, what more would you like me to say? I've answered the question twice. I expect the vote on Tuesday, Mr. McFadden.
Okay. Can I go back to this question of money? Your predecessor made quite a lot of the conditionality of the financial settlement, that it wasn't just the settling of past accounts, that this would only be paid if we got a satisfactory result on the future relationship. Has that been put into the withdrawal agreement, and if so, where?
I missed the last
Has
bit.
that conditionality been built into the withdrawal agreement, and if so, can you tell us where?
Well, I think, I mean, and they, the House of Lords reports that looked at this issue as well, and the importance of the financial settlement in terms of our sort of wider relationship. So I think there's a what's in the withdrawal agreement is the mechanism as to how the financial settlement has been calculated. What will then be in the bill will be the process by which we will pay. And again, I think that's one of the distinctions sometimes people confuse between the two. So the withdrawal agreement will set out the principles on which the financial settlement will be calculated. That's why there's a range between the 35 and 39 billion rather than a precise figure. But beneath that methodology, there's a complex interplay between what liabilities the UK has and in terms of what assets we would get in return and how those will interrelate.
No, I understand all that. The question I'm specifically asking is whether, whatever the actual sum is between the 35 and the 39 and so on, whether there is conditionality on paying that linked to a successful outcome on the future relationship, or whether that is legally binding on us once we ratify the withdrawal agreement. And if there is conditionality built in between stages 1 and 2, as it were, can you tell us the clause in the withdrawal agreement where that applies?
May I support you here, Secretary of State? Just to add, as I've tried to bring out a bit from Ms Reynolds earlier, what the withdrawal treaty does in Article 184 is provide for, is to create an international law obligation on both parties to turn the political declaration into legally binding agreements. That's therefore an obligation on both sides, and it's an obligation that needs to be read with Article 5, the withdrawal agreement, that compels both parties to use good faith in delivering on all of their obligations in the treaty. So the reason this is relevant is because clearly there are financial obligations in the treaty. There are also obligations to negotiate in good faith that future relationship. And so in that sense, the two are linked.
Sorry, I'll just give the bell a second. So do you see that Article 184, Ollie, as giving the UK the ability to say we're not going to pay part of this financial settlement at some point in the future?
So I think the correct legal view, but this is something that the attorney will no doubt be probed on this afternoon, the correct legal view is it creates an international law obligation on both parties to negotiate. That is not the same as an obligation to reach a particular outcome, but it's an obligation to negotiate in good faith. These clauses are not completely unheard of in international law, and the best endeavours provision here is, we believe, a strong one. What it means is that if there is obvious signs of bad faith in the execution of that obligation, then it raises a question that in the end will be susceptible to arbitration as to whether the other party is in breach of its obligations and which other obligations of the agreement should be suspended. I'm sorry, I know that's a slightly sort of techie answer to the question, but I want to be as accurate as I can be.
So there are circumstances under that article where the UK might say we are going to suspend payments or not make payments under the financial settlement if the UK judged that the future relationship negotiations were not being conducted under best endeavours or something like that.
I think what Article 5 of the withdrawal agreement does is create a very strong explicit presumption that both parties will execute all of their obligations in the withdrawal agreement in good faith. And if that's called into question by one party or the other, there is a strong dispute resolution mechanism in the treaty that deals with that eventuality, up to and including the ability for an arbitration panel to endorse the suspension of aspects of the agreement.
Okay, can I ask you one other thing, Ollie? I should echo what the chairman said about your efforts and the efforts of your team in putting all this together. It's been a huge effort and body of work. I want to ask you really about the link between what we're already committed to in the December agreement last year and the withdrawal agreement and the shape of the future. Because there's been talk about a spectrum of outcomes, and it's not just Canada or Norway. We've now got a more open canvas, as it were. But is that really the case? In other words, what I'm saying is, aren't the commitments that the UK has made to keeping an open border for the future, which is why we've ended up with a backstop, don't they also inform the shape of the future relationship? In other words, these questions of customs alignment, regulatory alignment so that the free flow of goods can continue, don't they inform the shape of what comes out in that spectrum that you referred to?
So, may I, Secretary of State? Sure. First off, I mean, I think the backstop has been a very, very particular instance of a much longer, deeper, difficult policy discussion with the European Union about how you avoid friction at a border. And I wouldn't want to pretend to you that we have yet won that argument in terms of what the government put forward in July as being the right systematic answer to that question for the UK as a whole. But what I think the Secretary of State and I are trying to explain is that by joint agreement with the EU, what we have ended up writing together in this declaration does not preclude that being the right answer. And certainly, as the Secretary of State brought out more strongly than me, it's brought out the joint determination of both sides to find a better way of doing it than is laid out in the backstop.
See, I think in a way you've been done a disservice because I think the commitment to no hard border, which is right and understandable that the country has made that commitment, and the commitment to frictionless trade point to an outcome, both of those commitments point to an outcome where we're adhering to one set of rules. And I think it would be better for ministers to have been candid with the public about that, instead of pretending that we still had a full canvas of options when those commitments clearly point to one kind of outcome in terms of our future relationship with the European Union.
I don't think there's a lack of candour. The point is, as Ollie's just alluded to, is there's a spectrum of options, and what the negotiation has done is keep that open. And I think that's part of the achievement that the Prime Minister has made. Clearly, frictionless trade requires more alignment. And there's a question then as to how that in the phase 2 is negotiated. But the point is the option of frictionless trade is still on the table, and that's clear in the political declaration.
Well, let me put it, I'll ask this one last question, Mr. Chairman. Let me put it a slightly different way round then. Do you believe that a Canada-style deal is consistent with the UK's commitment to no hard border and to have frictionless trade?
Well, the phase 2 negotiation will need to get into the detail. We start from a position, let's not forget, of alignment because we've been part of the EU. So we start from a very different position to the Canadians and to others because we are already aligned. What's also clear in the text is the shared commitment on both sides in terms of the shared values. Now, so that's the premise through which the negotiation will be conducted. But this will be part of the detail of what we explore in phase 2.
No, I'll press you a little bit further. I'm sorry. Would a Canada-style free trade agreement or the Japan free trade agreement, one of these, latest in class EU free trade agreements be compatible with the commitments that your government's already made? It's not a trick question.
No, I'm not suggesting for a minute, but what I'm saying is that it's in both sides' interest. I mean, let me give a specific. So if you take medicine, I mean, there's been a lot of debate in terms of the importance of keeping the supply as frictionless on medicine. What tends to get less coverage is there's 45 million packages of medicine that go from the UK to the EU each week. So it's in both sides' interest to have frictionless trade. That is in the mutual interest of ourselves and the EU 27. Then within the phase 2 discussions, we will need to then get into discussion from a starting point of regulatory alignment, which is what is part of the unique relationship we have. We start from alignment as to how that will be managed alongside with the aspiration, which is as frictionless as possible.
At some point, you're going to have to level with the public about what these commitments on no hard border and frictionless trade mean. And part of your trouble is that that hasn't happened so far. So people are being told that all these options are on the table when they're not really. And I think that moment should come sooner rather than later. I'll leave it there for now.
I recollected that the Prime Minister had actually said that she thought a no-deal Brexit would be better for the UK than a Canada-style agreement. I think that's what she said when she was at the United Nations. But anyway, we will move on. Chris Chope.
Thank you, Can I take you back, Secretary of State, to this issue of the relationship between the withdrawal agreement and the future arrangements agreement? We are fortunate in having received advice from the House of Commons EU legislation team on this issue. And the legal note that they produced says the fulfilment by the UK of its obligations under the withdrawal agreement, for example, making payments under the financial settlement, are not conditional on reaching a satisfactory future arrangements agreement. The legal advice then goes on to say that, refers to Article 184 and to Article 5, and says, whilst these are legal obligations at the international law level, they do not stretch as far as obliging the European Union to enter into a future arrangements agreement which it does not consider to be in its interest. And if the UK wanted to try to enforce this obligation, the obligation to use best endeavours and be of good faith, the legal route of recourse would be by complaint to the Joint Committee and ultimately dispute resolution before the European Court of Justice. And then it goes on to say that there is no compulsory system of determining and enforcing any sum that might be owing under international law, and that the degree of detail in the political declaration affects the assessment of the risk of the lack of conditionality in the withdrawal agreement. The language of the political declaration varies. Some provisions are couched in firm language, with or without conditioning words. Some are matters for consideration or exploring, or matters the parties envisage happening. Do you accept, Secretary of State, that that is an accurate assessment of the legal status of the linkage between the withdrawal agreement and the future agreement, the future arrangements agreement?
2 points. Firstly, the financial settlement, and perhaps if I just reference the Lord's report, because the Lord's report is often quoted as grounds for not making any payment at all, that we shouldn't be making any payment under the 39 billion. And Para 137 of the Lord's report said, quotes, the political and economic consequences of the UK leaving the EU without responding to claims under the EU budget are likely to be profound. And as the Prime Minister has repeatedly set out, we are a country that honours our obligations. Those obligations are significantly less than the EU was looking for. They started at around 100 billion, I think, from memory, and we now have a range of 35 to 39 billion. So, and as part of the implementation period, we are obviously continuing to gain many of the benefits, including the receipts that come our way from assets and other things. So the point is the financial settlement reflects our legal responsibilities, our legal obligations. The Lord's report recognises that, and I think that is absolutely right. There's a separate point in terms of whether the EU, as part of the political declaration, honours the commitments it's made in that political declaration. I think we've already covered that terrain to some degree, in that there is a clear legal connectivity between the withdrawal agreement and the political declaration. There's also a political, I think, responsibility, political commitment, which is partly why that document was subject to such negotiation. And so I think it does set the clear direction of travel for the future trade agreement, but it is connected to, but not dependent on, the financial settlement.
So you accept what the legal note, which I've read out, asserts? You accept that?
There's
nothing wrong with it. There's nothing wrong with accepting it.
What I accept, Mr. Jobe, is that as part of our legal obligations, we have legal obligations to the European Union, and as part of that, that does require a contribution. And I know there are some colleagues, including around the table, who feel that we shouldn't pay a penny to the European Union. And I respectfully disagree with that position, because I think, as the Lords have set out, walking away from our legal obligations and not paying a penny, I don't think would put the UK in good standing as we go out into the world to trade.
And that's not the question I'm asking about. I'm asking about the conditionality and the linkage. And can I remind you, Secretary of State, that when the Prime Minister made her Lancaster House speech, she said, I want us to have reached an agreement about our future partnership by the time the 2-year Article 50 process has concluded. And you would accept we haven't got anywhere near reaching such an agreement about our future partnership. And the reason that the Prime Minister wanted us to have agreed both things was so that there could be linkage between them, and we wouldn't end up paying £39 billion without being sure what we were going to get in return.
The point is, it depends. The crux of the question goes to the specificity of how much detail is in the agreement. The point is that the political declaration does have clarity in terms of things that the European Union have agreed. The UK, as part of our future relationship, will be able to enter into with them. It's perhaps not to the level of detail that you would prefer, but I would argue that it is significant. But Ollie, I think you wanted to just come in on that.
I just wondered if I could help on the specific question you were asking about the publication you referred to. Just to say to the committee, I think whilst we've been here, the government's published its own legal assessment of the withdrawal treaty, and there is a paragraph at 77 of that document that explains our take on Article 184 and Article 5. I think to a non-lawyer, what it says is not inconsistent with what you read out, Mr. Chope, but it's the important point that I was trying to get across to your colleagues is that what 184 does is it creates an obligation as to the conduct of the parties. It doesn't create an obligation as to a particular outcome, but it says that the conduct of the parties must be informed by this political declaration.
And anyone that's more familiar with the commercial courts will know that you can't legally compel another party to conclude a legal agreement. What you can put into legal text is a requirement for another party to act in best faith, to act reasonably, those sort of requirements. You can't compel them to conclude. And in essence, that is the distinction that's coming out.
Well, I don't think anybody's disputing that, but you've said, Secretary of State, that it's all quite clear. Can I ask you, give you some specific examples that in paragraph 26 of the political declaration, it says the parties will put in place ambitious customs arrangements. What does that mean? Then paragraph 54 says the parties agree to consider addressing social security coordination, to consider addressing social security consideration. And then in paragraph 55, the parties will explore the possibility to facilitate the crossing of their respective borders for legitimate travel. And then in paragraph 20, the parties envisage having a trading relationship on goods that is as close as possible. What legal enforceability is there in relation to any of those vague, waffly, ambiguous phrases?
Well, I mean, the text refers to it being a framework. What this is doing is setting in essence, the negotiating instructions, the framework for those future trade agreements. I'm not suggesting to the committee there isn't significant work to do in phase 2 as we put those into legal text. But what it does show is the framework in which the EU27, the Commission, the UK will conclude those trade agreements. That's what's being set out in the political declaration. And as Ollie has referred to, there are clear legal underpinnings to that in terms of the way the European Union must undertake and conclude those negotiations. That's what has been agreed.
Okay, finally, can I just say this? You and I, Secretary of State, were both elected on the same manifesto in 2017. Page 38 of that manifesto said, "We believe it is necessary to agree the terms of our future partnership alongside our withdrawal, reaching agreement on both within the 2 years allowed by Article 50 of the Treaty on the European Union." You've admitted today that that commitment in our manifesto has been abandoned.
No.
Can I go back to
No,
Mr. Bowen's question and ask, when was it abandoned?
No, well, with respect, I haven't said anything of the sort. What that set out was that we would reach an agreement after a very intense 2-year negotiation. The Prime Minister has secured that agreement. One of the concerns that colleagues across the House has raised as to the legal force of that agreement, and we've covered today in the session the legal connectivity as to why the legal text in the withdrawal agreement gives effect to the political declaration. But it's simply not the case to say that an agreement hasn't been reached. The political declaration has been agreed with the other side. That sets a clear template, a clear framework. It perhaps doesn't have the level of detail on every issue to which, Mr. Chope, you were hoping, but I don't think it can be said that an agreement has not been reached. It has.
Okay.
Yeah.
Thank you, Chair, and thank you for coming to answer our questions. Now, we heard this morning that an immigration white paper will not be coming before the vote. Perhaps you can help me out. In light of the government's intention to end free movement after December 2020 and introduce, as you have already said this morning, a skills-based immigration system, I asked the Prime Minister last week a question. And I asked, in January 2021, an incoming EU citizen coming to Dublin, travelling on to Belfast and then to the rest of the UK, where will the immigration border be? And the Prime Minister answered that there would be no immigration border because we are in the common travel area. Does this mean the government actually had discussions with the Republic of Ireland that they too will introduce a skills-based immigration system, or that they also will end free movement of EU citizens, which I don't think, because it would be a very amazing news if that had happened. So I assume not. And therefore, I repeat my question. In January 2021, an incoming EU citizen coming to Dublin, travelling on to Belfast, and then to the rest of the UK, where will the immigration border be?
Would it help if I came in here, Secretary of State? I think the Home Office's plans, which, as the Secretary of State has said, will be set out in detail in due course, are based upon the idea that for most EU citizens, the immigration control, your right to work and stay in the United Kingdom, will not be exercised at the border, but exercised in country. So what we're talking about here is that I don't think either side wishes to gum up the border by removing the e-gates and doing all sorts of things that will make it more difficult for people to move for legitimate purposes in both directions. But what that means is that people coming through Ireland into the UK, either via the Northern Ireland or directly, if they want to work and to stay in the UK, they'll have to comply with UK immigration law if they're EU citizens. But it doesn't mean that you need hard infrastructure between Ireland and the UK any more than you need more than the e-gates today.
Can I ask again? But somebody coming into Dublin, it would then be the Irish government that would check that an incoming EU citizen would have the right documents either to work or to travel in the rest of the UK. Is that what you're saying?
No, I think the Home Office will set this out in more detail, but the kind of in order for this to work, for someone to work in the UK, they will need the correct documentation to be able to work in the UK, and that's very similar to somebody arriving today. What it doesn't imply is any new particular control on EU citizens coming in through Ireland.
Or indeed from France to the UK, because there's a reference to, for short-term visits, that visas would not be envisaged, and therefore someone from any EU country could arrive in the UK at Heathrow Airport, and if they're coming on holidays as a tourist, they could do so. They wouldn't require a visa or a permit. That's my understanding what the government's plan is. But as you've just said, if they want to rent property or work, then they would have to get the appropriate permission, visa of some sort, depending on what the Home Office eventually announces. Is that what the government's intending?
Well, the immigration white paper will set out the detail on this. I think what Ollie was referring to is currently employers have responsibilities on registering, and so it will be for the white paper to set out to what extent that has a read across. So
but you're not proposing that visas for tourists coming to the UK.
Well, I think there's already
from
the EU as well commitments around 160-day visits, I think, for businesses and tourists, and I think that agreement's already been reached with the EU, and that's in the text. So again, I think that one's already been covered, hasn't it? Yeah.
So I mean, I think this is an area, Ms. Hophouse, where the phrase free movement is a bit misleading. Free movement, the full phrase was always free movement of labour, and so for people to be able to live and work in the UK, there have always been requirements in order to ensure that that's done legitimately. And obviously, depending on the Home Office white paper, we'll be looking again at what those requirements are in future. In terms of moving across the border, the Chairman is right that the government has said for some time it doesn't want to make that process any unnecessarily more difficult for people than it is today.
But can I insist, the UK, as I understand it, will want to move away from an immigration policy that's different from the Republic of Ireland, because in the Republic of Ireland, EU citizens can continue to come and get, have free movement of labour, whereas that will terminate for EU citizens wanting to work in the UK. So there will be a divergence of policy, and how can who is going to be responsible to actually check a work visa of an EU citizen that is different from what the Republic of Ireland requires?
Well, I think firstly let's just distinguish, because under the implementation period, EU citizens would be free to travel.
No, I asked 2021.
So this is that is what the Home Office white paper will cover. But the point is, in the short term, the implementation period, the status quo would continue.
My question was for 2021, and we do not know at all what this arrangement is going to be like, because the white paper is not being published. So
well, I think the wider direction of travel that government has signalled is that we want to move away from a nationality approach to much more of a skills-based approach. So one would expect a direction of travel more akin to other third countries, but it will be an issue for the immigration white paper to actually set out the detail.
So we don't know yet?
Well, the immigration white paper will set out the detail. I don't think it's appropriate for me to preempt. And again, I mean, there's a fairly standard approach to these things that other departments set out, and Mr. Krabs, being a member of the Cabinet, he is familiar with it. Other departments will set out their approach in due course. I don't want to preempt another department's announcement.
Can I ask one separate question?
Yep.
So, your predecessor only on the 21st of October said a good deal is in sight, and on the 23rd of November he said this deal would be worse than membership. What has changed within that month? Because obviously for bystanders and outsiders this is extremely difficult to understand. What has changed in that month, or did your predecessor suddenly have a light bulb moment?
No, I mean, my predecessor is one of, I think, the most respected. He's very bright, and I think very respected by people across the House, and he's can very eloquently speak for himself. So it's not for me to comment on the position that he's taken. I think the point is that, from my perspective, it is a question of assessing the balance of risk. The risk of uncertainty, in my view, is one that would be very concerning to business, concerning for jobs for my constituents and yours. And we have a deal on the table which respects the result, delivers on the referendum, delivers on things which you've just been referring to, like a skills-based immigration system, such as on having control of our fishing waters, such as taking our agriculture out of the CAP. I represent a farming constituency where the CAP has long been a cause of concern. So it delivers on the referendum result, but does so in a way that delivers those frictionless an approach at our borders, which is good for business. Dominic, as I say, will speak for himself, and I think I should... But
nothing changed in that month in terms of the direction of the
Well,
outcome.
I think, as I say, Chair, I think it's for Dominic, as a former member of this committee, no less, will speak for himself in due course.
You're the first Secretary of State for exiting the European Union who has not previously been a member of this committee. So that's a claim to fame, if nothing else. And, well, indeed. Right, Andrea Jenkins is next.
First of all, Secretary of State, wish you a good look in your new role. I know it's a challenging time ahead. Secretary of State, next week we are voting on your deal, and in your opinion, are you confident that you're going to secure enough votes to get it through the House?
Well, I think it's going to be challenging. I think everyone recognises that. It's an issue on which a great deal has already been said. But there is clearly time between now and the vote, and I think
so will it
what
get
has
through?
come, well, as a former whip, one waits for the vote to see. But I'm confident that we can deliver this deal because I think it is in the national interest. We've had a very divisive...
You're confident you can deliver the deal, but
I think, as I say, I think it's
challenging.
It's challenging. It's challenging because a lot of colleagues have already spoken out on this, and I think part of the challenge is this complex legal wiring between the withdrawal agreement and the political declaration. It's complex in terms of the economic analysis. It's complex in terms, well, one can run through a
So assuming
wide
it doesn't
list
get
of
through
issues,
next week, Secretary of State, what's your contingency or plan B?
Well, our focus is on delivering the vote, and that's what we're focused on. And
but surely it's the job of government to look beyond that, because we know...
One hears a lot about this plan B. I mean, the Prime Minister has been very clear that...
So there is no plan B? There's no contingency plan?
The focus of government, Ms Jenkins, is on delivering this vote.
This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the
part of this government's approach to tackling serious violent crime and the running of drugs outside our major cities. Everything we've learned from the examples elsewhere, it is effective multi-agency partnership that works, and government is actively supporting that through funds such as the Early Intervention Fund.
Anne Abbott.
The Minister deliberately and consistently confuses money raised locally by the precept with money from central government. But the Minister will be aware that the Home Affairs Select Committee, the National Audit Office, the Public Accounts Select Committee have all sounded the alarm about inadequate central government funding. And most recently, the Mayor of London has said London police numbers will plummet without increased funding. When will the Minister stop blurring the facts and make sure our police get the money they need?
Well, what I say to the Honourable Lady, I'm not blurring any facts. What I am is in challenging a deception by the Labour Party on the British public that somehow someone else will always pay. The government has no money. Every pound we spent is raised in tax or borrowed on which the taxpayer pays interest. That is the fact. If we want more investment in our policing, and we do, then we have to pay.
Vincent Cable.
Further to the Minister's answer on police pensions, does he accept the Chief Constable Thornton's estimate that this will cost the police service over 420 million, or the equivalent of 10,000 police officers, and explain why this will not be met in full?
We'll set out the details later in the funding cycle. What I point out to the Right Honourable Gentleman is the Treasury has made it quite clear that their intention of funding most of those costs, and the rest of the solution, as I've said, will be clear in the police funding settlement.
Siobhan McDonough.
Question number 9, Mr. Speaker.
Mr. Speaker, the government this year took through a police funding settlement that resulted in an additional £460 million of public investment in our policing. Most police and crime commissioners are either maintaining or increasing the number of police officers.
One of the casualties of the cut of 21,000 police officers since 2010 has been the Safer Neighbourhood team in Mitcham Town Centre. The consequence of this has been an increase in drug dealing, street drinking, fighting, antisocial behaviour and men urinating in the street, meaning that women do not want to take their children into the town centre. When will the Home Office accept the correlation between visible policing and crime so that we can afford enough police to put more bobbies back on the piece in Mitcham and in every town centre?
Well, what I say to the Honourable Lady is I hope she will welcome the fact that the Met Commissioner, I speak as a London MP and Minister for London, that the Met Commissioner is active recruiting an additional 1,000 officers on top of the 1,000 she needs to recruit to stand still. And I hope she will welcome that.
Neil.
Thank you, Mr. Speaker. Lack of visibility is made worse when the police do not use the resources which they do currently have to follow up crime. And that's a particular concern to residents in Bickley, in my constituency, where a 29% spike in largely burglary and theft has not resulted in victims being contacted in a timely manner, even when they have been able to hand over, in many cases, CCTV footage. Please meet me to discuss this.
I will certainly do that, not least as I've had similar experiences in my own constituency.
Gloria De Piero.
Speaker, this morning I learned that a cafe in my constituency had been broken into for the 3rd time this year. It's not isolated. Burglary in Nottinghamshire is up this year, as it was up last year. How much more evidence do we need to get more police on the streets?
Well, what I say to the Honourable Lady is in a police settlement that she funded against additional investment has gone into policing, and as I said, most police and crime ministers are actively recruiting additional officers, and I hope she would welcome that.
Matt Warman.
Speaker, police numbers of course depend on the entry routes. Does the Minister agree with me that it is right that we